First of all, I want to thank the Senator and her staff for having met with us and having heard some of the concerns. And I think that generally speaking, when we're talking about attorney's fees, one of the reasons that we strive to protect those is because the award of attorney's fees is not generally recognized under the common law. If you're in a negligence case, each party carries their own attorney's fees. So we put attorney's fees generally into provisions of law when we're trying to balance the parties. There may be that we have a type of claim that's so small that without the benefit of attorney's fees it can never be brought. Or in this case, we're talking about where it's a suit against a governmental entity, or it could even be suits between governmental entities. But in the general context, we're looking at a suit between some form of individual or corporation and the government. And so the award of attorney's fees is about balancing, David versus Goliath. The state with unlimited resources versus people or individuals. And so the types of cases that you're going to see under the Uniform Declaratory Judgment Act are things like eminent domain cases, potentially water rights cases. You could be looking at school district issues. There's a case in dealing with homeschooling. Y'all were just debating issues in terms of, I think, homeschools and about those things. And homeschools were fighting about curriculum standards, and so they were bringing a declaratory judgment act. So it's really about individual rights and property rights when there's conflict with the state. And if we don't have the award of attorney's fees, then we don't believe that those cases can be brought. I would also point out, and happy to provide the Senator and her staff with this case, there is existing case law which says that a party that does not prevail and was awarded attorney's fees, the appellate court actually reversed that and took those away and said it wasn't appropriate. So while the statutory language would allow the court to award attorney's fees to a non-prevailing party, our courts of appeals have not been willing and have showed reluctance to do so.
When have they done it? I'm just curious.
It could be in a situation, I think you could see an important policy or procedure issue for the state. It might be in the area of redistricting, perhaps, when there's good faith disputes over what should happen and we're dealing with civil rights and there's a battle that's ongoing. They might not ultimately win the issue, or they might not win all issues, but they did prevail on some. That would be an instance where perhaps attorney's fees would be warranted. I was going to point out that the state's not limited in the attorney's fees that it can obtain. And again, if they're battling a corporation or a person and the state wins, then the court can award against the losing party those costs. This could also be in an entity where governmental entities are suing themselves. I saw a couple of cases where cities against cities were suing. So again, the issue of attorney's fees that comes in, I'm not sure you would want to limit them. But mostly the issue is that you're trying to balance the equities. You want these opportunities for people to bring these issues, but in all instances, they can't do so against the state.
Okay.
They just can't do so against the state in that limited entity. It is a very, and the only time that this cap would come into effect would probably be in the largest, most important, most contentious issues in order to get an attorney fee award of $250,000.
On cases like this, if somebody's suing the state, you have any rough idea? I'll ask the AG's office, if not. How much money does the state normally spends in staff time?
I don't. Obviously, I would assume that the state maintains records and they can prove an hourly contribution to the case. I would assume that to be the case. I assume that they make those petitions when they do so because, again, that's part of the process of resolving or the potential of not pursuing is you can be hit with an award of attorney's fees.
This would knock out most redistricting cases, I assume. It would knock out school finance case.
Again, by capping the fees, you create a situation where the parties who would challenge that cannot afford to bring the case.
Unless somebody was going to do it pro bono, I'm assuming.
Correct.
But if they were going to get the possibility of being paid, all those cases would be knocked out.
It would create a significant disincentive for an attorney to be willing to fight the good fight, regardless of the issue at hand, if it was a big enough matter and this $250,000 cap was going to come into play.
You know if any other state does this?
I do not know whether they do or don't.
Any other questions? I'd like to bring up Shelley.